All right, the other half of the freedom of religion that we need to talk about is what we call the free exercise clause. So the establishment clause was all about making sure that the government didn't tell you what religion is best. The free exercise clause is all about the government not getting in your way when you practice your religion. So what we see here is a group of students praying. I'm assuming like before school or something like that, but we were mentioning how there was a case that prevented the school from leading prayer. But the other side of things is that the government cannot tell this group of students that they are not allowed to pray. So that's an example of what we're going to be talking about when we talk about the free exercise clause. So this would be an example of, this is not the school holding a prayer, but this is a group of students who are choosing to pray. And those two things are very different when we start to talk about what the government can and cannot do. So the free exercise clause, we said the words of the amendment are going to say Congress will make no law that prohibits the free exercise of religion, right? Congress shall make no law that respects an establishment of religion or prohibits the free exercise thereof. So this prevents the government from stopping your ability to worship however you please. This is making sure that the government does not get in people's way of practicing their own religion however they see fit. So like what we see in the picture here, this is at a prison, and like worship service has to be allowed to go on at a prison. That's just an example of how the government, regardless of whatever else is going on, if these men are imprisoned for whatever crimes they may have committed, the government cannot prevent them from exercising their religion however they choose. So what we're going to look at, we're going to talk about the limits on free exercise here, because free exercise is going to mean that you can practice your religion however you want, but it's not going to be an excuse for just any behavior. You are allowed to have any belief that you want to have. There's no way to stop anyone's religious belief, but they may not always be able to practice those religious beliefs exactly the way that they want to. So we'll look at that. So remember, keep that in mind the whole time we're talking about stuff, that you're allowed to believe anything you want, but you may not be able to practice all of that. That's where we're going to find limits on the free exercise clause. So here's the complication with your religious practices is sometimes certain religions may forbid you from doing things that in society or the government we find necessary. For example, there are religious groups out there who are opposed to paying taxes because those taxes go to fund the military, and they have a religious objection to the military. Well, those people do not have the First Amendment right to never pay taxes. So just because their religion says they shouldn't be participating in that doesn't mean that free exercise is going to protect them. The other side of things, sometimes religions require stuff that we're going to find unacceptable, that the government can't allow. Right? What if your religious belief includes human sacrifice? You can believe that, but obviously the government cannot allow that to take place. We're going to get into some court cases and talk about when the government can limit religion, and what we have decided, this is going to be kind of a legal term here. The government must have a compelling interest in order to restrict your religious practice. So that means in court, it's up to the government to show or to prove why a law is necessary if it's going to be something that restricts people from practicing their own religion however they want. So the government, if it is preventing someone's religious belief, they're going to have to prove that it's necessary to have this law, that there's not an alternative way to do it that would not infringe on people's religious beliefs. So let's look at some examples here and start with our first court case that deals with free exercise. All right, so here is a court case that we absolutely have to know by name. This is called Wisconsin versus Yoder. And this is a court case about Amish families and requirements that people attend school. So like most states, Wisconsin had laws that require people to go to school until they reach a certain age. Amish families were pulling their children out of school after the 8th grade because after 8th grade, they need to educate their children differently in their own Amish communities and learn their Amish way of life to practice their religion. But the state had a law that says, everyone has to go to school until they're 16. Now, the law is not intended to discriminate against the Amish religion. The law has nothing to do with religion, but the law did restrict the Amish family's ability to practice their religion how they see fit. So in this case, there is a conflict between the law that says all kids have to go to school and the religious practices of the Yoder family, the Amish families here. So they were fined because they didn't send their kids to school. They went to the Supreme Court, and the Supreme Court ruled, yes, this is a violation of the free exercise clause. Like there's no actual reason. Remember the words compelling interest. Like, is there any reason why the state must force Amish children to go to school beyond the 8th grade? And if think about all the things that you have learned in high school these last 4 years, are these things that you would absolutely need to know if you were going to continue in Amish tradition or whatever? So this conflicted, like the stuff that they have to do in high school would conflict with the religious teachings and with the way of life of Amish people. So the state doesn't have any reason. The state can't prove that Amish kids absolutely must attend high school. So these people's free exercise of religion rights were violated. And so Wisconsin versus Yoder is our big free exercise case. In this case, even though the law had nothing to do with religion, the Amish families did not have to continue to send their kids to school. So there's a big deal case we're going to come back to and talk about. So these are just some other cases that deal with the free exercise of religion. We won't really have to know these by name, but they follow kind of the same precedent and just set some limits on people's ability to practice their religion. So one of the big ones is Reynolds versus the United States. This was a court case about polygamy. And this person wanted to marry multiple women, and the state laws banned that from happening, and the government, they went to court, and the court sided with the government and said, okay, we do not have to allow polygamy. The state does have a compelling interest to limit the amount of marriages a person can be in to one. And so even though that may be Reynolds' religious belief, they're not allowed to practice polygamy. Another case here, Tarcaso versus Watkins, this was about states that required a religious declaration to hold office. And so this is not allowed. So states, this is a lot like the religious test, but lots of states had laws, including Tennessee. The Tennessee Constitution says that that a person who denies the existence of God cannot hold a seat in the legislature. And so this is an example, like this Supreme Court case would strike down that part of the Constitution. Murdoch versus Pennsylvania is a case about people handing out religious material. This, has happened at school from time to time when we're in school. Maybe people want to hand out Bibles on the sidewalk and stuff like that. They have to be allowed to exercise their religion in that way, and the states can't make them get licenses and things like that. And this last one here, this is a newer one, and this is going to be one of the issues that we'll talk about a lot as we talk about religion here. But the Masterpiece Cake Shop was a very fancy cake baker, and they argued that if they were, if they had to serve their cake if they had to sell their cake services to same-sex weddings, then their religious freedom was being violated, that they were being forced to go against their own religious beliefs to provide a service for a same-sex wedding. Now, this court case was decided for a different reason here. There were some technical problems in Colorado with how they did the law, but this is one of the battlegrounds of religious freedom rights that we're dealing with now. So without dealing with like actual court cases or whatever, these are just some things that the government can do. So these are places where the government has limited people's religious practice, and it's okay according to the court. So like obviously the government can prevent human sacrifice. The government, we just mentioned the court case here, the government can ban polygamy. There have been several cases where the government has like built roads and stuff through sacred indigenous people's lands, and that is been held up as okay by the court. So like even though you're like taking away some sacred lands to build roads, that definitely limits people's free exercise of religion, but the court has sided with the government there. Parents, like regardless of their whatever their religious beliefs are, they're not able to deny medical treatment to children. So if your religious beliefs would oppose medical intervention for a few different things, parents are not allowed to deny medical treatment for a child. That's one of the places where the government puts a limit there. And religious schools, like one of the things we'll talk about is like religious organizations don't pay taxes. That's part of the separation of church and state. But if schools were to discriminate in violation of things like Brown versus Board of Education or the 14th Amendment or the Civil Rights Act, then those schools may lose their like tax exemption status. So those are some things that give the government power to limit religion. And here are some places where the government has like lost. So the government cannot limit free exercise in these instances. So some groups want to sacrifice animals as part of their worship service. And the government cannot pass laws that ban that because those laws specifically target the religious practice. There's no reason that the government would have to ban animal sacrifice as part of a religious service. People, like even if like drafted into the military or whatever, they can object to military service because what we call a conscientious objection. This may be based on a religious belief, and so the government cannot force you to serve in the military if you have religious beliefs in opposition to that. The government cannot force any stating of the Pledge of Allegiance type activities. That includes like at school or whatever. You're not allowed to be like punished for a refusal to pledge allegiance to the flag or things like that, because that infringes on people's religious beliefs, religious practices, opposed to, any sort of pledge or oath in that way. So these are places where the government, has been prevented from limiting these religious practices. All right, and then this is a big religious freedom court case, and this has really started a series of laws that are setting up our like current battles over religious freedom here. But this was in the early 1990s. This is called the Employment Division of Oregon versus Smith. And so sometimes we see this as Employment Division versus Smith, or sometimes we see it as Oregon versus Smith. I just put the name up here all the different ways so that we make sure we recognize that. But this is a case about illegal drug use. Like, can you use illegal drugs as part of a religious ceremony? So this case got all the way to the Supreme Court, and this was about some Native American people who were using peyote as part of a religious ceremony. Peyote is like a hallucinogenic drug, and it is banned. You can't, buy, sell, consume it or whatever. But they were using this as part of a religious ceremony. And so the question is that okay? And if you think about it, the largest religion in the country is Christianity. And there are religious ceremonies involved in Christianity that may sometime include the drinking of wine. There are there are places of worship all over the country that give wine to people under the age of 21. And the government doesn't bust in to break these things down. They're not like arresting pastors who serve wine, small amounts of wine to 16-year-olds or whatever. So when this gets to court, these guys are not punished for the illegal drug use during the religious ceremony. So the government is not running around trying to catch people who may engage in drug use in a religious ceremony. But there was a different problem with these guys. So they weren't punished for using an illegal substance, but when they went back to their jobs, they were fired. And they were fired because they failed a drug test. And so since they were fired for misconduct, according to their job, they were unable to get unemployment benefits. Like, they were not able to get any of government assistance to help people who lose their jobs. So in this case, even though the state didn't arrest them for using the peyote in the religious ceremony, but the state has indirectly ended up punishing them here. So they've been punished because of their religious belief. They consumed an illegal substance and lost their job, and so now they're unable to get employment benefits. And so when this case was decided, the Supreme Court sided with Oregon. These guys were punished, like they were denied their unemployment benefits. And so what happened in this case is the government didn't they didn't arrest people for using peyote at the religious ceremony, but they were indirectly limiting these people's ability to practice their religion, because they did end up indirectly punishing them for the drug use. The argument here for the government was that the government interest in enforcing this law, like they have to enforce a law against illegal drug use, that is more important than protecting this minority group's religious freedom. And the ruling here told us that people are not allowed to ignore laws. They call these laws of general applicability. So you can't just ignore laws as an expression of a religious belief. And so when this case was announced, what happened is these people were seen as being punished for a religious belief. They were punished for drug use, but that drug use was part of a religious belief. And in this case, the state did not protect their religious freedom. And so this was a pretty unpopular decision among all sorts of religious groups around the country, because if this group, even though, not a lot of people practice this religion where they would consume peyote in a religious ceremony, this was unpopular because if the government was going to limit their religious practice, then the government could limit anyone's religious practice. So I mentioned that case was unpopular, and the response of Congress here was to pass a law that would have protected those guys a little better and would have cleared up this complication between the state and religious freedom. So this law says that the state has to use it's another legal term we call strict scrutiny. And that means that if the state is going to limit religious belief with a policy, then they have to prove that policy is absolutely necessary. So, laws that have nothing to do with religion. Think back to Wisconsin versus Yoder that we were talking about a few minutes ago. Making children go to school by law has nothing to do with religion, but this was a law that did burden a religious practice. So even though they didn't pass that law to discriminate against Amish people, they did interfere with Amish people's religious practice. And so the Religious Freedom Restoration Act, the RFRA, is set up to try to make it easier to protect people and their religious practice. So this makes sure that laws cannot harm religious practice unless the government can show that the government has a compelling interest and that it's absolutely necessary that this law be in place. So it's not an absolute protection of religious practice, but we'll make sure that the state has to do anything possible to protect people's religious freedom first. And so that will bring us to our kind of more modern Supreme Court case. This is from just a few years ago. This is Burwell versus Hobby Lobby. And this was a court case that came up as a response to the Affordable Care Act being passed in 2009. So where we need to start here is you guys probably know the store Hobby Lobby. Hobby Lobby is owned by a family that describes themselves as evangelical Christians. This is one of the tricky parts of the case here. Is Hobby Lobby is actually just owned by this one family. Like, you can't buy stock in Hobby Lobby. It's not owned by thousands of people across the country. The Affordable Care Act included some rules about what type of insurance had to be provided for all businesses that had more than 30 employees. So part of those rules said that that all businesses had to provide certain types of contraceptive coverage to their employees, and that included a couple of birth control options called what are called the Plan B pill and IUDs. And so the owners of Hobby Lobby feel that these particular types of contraceptives present a violation of their own religious beliefs. So there's complicated issues here about how the family feels that the government is forcing them to provide medical services to their employees through insurance that violate the family's religious beliefs. And in this case, the court, even, Hobby Lobby is a business and Hobby Lobby is not an individual, but the court ruled that the business, that Hobby Lobby, the company, is allowed to have a religious exemption from the law. So in this case, what happened is Hobby Lobby was able to, they won the case. Hobby Lobby does not have to provide these types of birth control options through their insurance plans. So this is the first time that we see a company or like an organization, a corporation here, able to have religious beliefs. So in this Hobby Lobby case, this is the first time that the Supreme Court is saying that a corporation can have a religious belief. Now, this is specific to the type of corporation that Hobby Lobby is. Like I mentioned, they are owned by a family. Even though it's a very big company, they're not owned by like a bunch of business people. They're not owned, like they don't have stocks. So this would be different if we're talking about like Coca-Cola or Walmart or Amazon or any of these companies that like technically have thousands and thousands of owners through like stock purchases. So because this family owns the business and they have strong religious beliefs, then the company is allowed to exercise its own religious beliefs here. So the company was able to get an exemption, and this got rid of part of the Affordable Care Act that forced employers to cover contraceptives for their female employees. And so what the court ruled here is that this came after that Religious Freedom Restoration Act. So the government was not able to prove that this policy was absolutely necessary and that this policy, that they had tried all the other alternatives that would not impose on people's religious beliefs. So this is an important case because it is, the court is siding with religious freedom against the government policy, and not just religious freedom of individual people, but now religious freedom is being extended to corporations as well. So following the Hobby Lobby case, we've had a bunch of state governments, I think 21 of them, state governments have passed their own religious freedom restoration acts. And this just like reiterates the idea that the government is going to have to show that they've done everything possible to avoid infringing on people's religious freedom when they pass a law. And so some of these, not all, some of these are old acts, but a lot of the new ones here include language that is sending us into our most recent battleground in religious freedom issues. So Indiana was the first, not the first state to pass one, but the first state to pass one of these following the Hobby Lobby case. And this includes some complicated language here. So there you see, at the time, Indiana Governor Mike Pence signing this law. And this, for religious conservatives, this made Mike Pence something of a national figure and one of the main reasons why he was added to Trump's campaign in 2016. But this law in Indiana, under what they call a Religious Freedom Restoration Act for the state, this law prevents the government from burdening anyone's exercise of religion. And it also includes a definition that businesses are people. So what that means is that people and businesses can possibly deny services to individuals if providing that service is a burden to their religious beliefs. So this is taking us back to that issue of the cake baker. Like, is the cake baker forced to have his religious practice limited if he is forced to provide cake baking services to a same-sex couple? And so this law recognizes the business's right to free exercise. And this is going to allow free exercise of religion as a defense in court against any type of discrimination. And so this Indiana was the first state, but like 4 or 5 states have passed similarly worded laws, and they cause controversy for a little while in the states because the laws are worded in a way that create legal loopholes for discrimination, particularly discrimination against same-sex couples. And so that's just where that's where the free exercise issue is at the moment. This is kind of where the legal battleground in this religious freedom right is. We don't have a lot of attempts by the government to like make an official religion in 2021 or anything like that, but the main religious battleground in 2021 is the balance between protecting people's individual rights to practice religion and civil rights protections to ensure that there's no discrimination in places that serve the public. And so that is just kind of like the fight that we are in the middle of at the moment. The courts are deciding these types of cases where people will use their religious freedom as a defense when refusing service to specific people because of religious beliefs. And so we'll talk about this in class. We'll end up like going through this as part of an argument and seeing what you guys think about that. All right. Now, I know that was a lot. We're going to talk about this a lot because religious freedom is complicated. One of the most, obviously, like we talked about, the framers decided it was the most important individual freedom. So we've got a lot to talk about together and figure out what you guys think about people's right to exercise religion and making sure that the government is not restricting anybody's ability to practice religion. Here we have President Trump. This is probably going to end up being one of the most famous pictures of President Trump taken. This was over the summer where Trump wanted to take this picture holding this Bible in front of the church across the street from the White House, and ended up having many protesters tear gas to make way for him to get over there to take this picture. But anyway, let's talk about what we need to know about the freedom of religion. All right, here's everybody getting to meet the Pope. Looks like everyone is having a great time here. So let's talk about those things we want to make sure we understand from today. First of all, absolutely make sure that you guys understand the 2 parts of the freedom of religion, that you could compare the purpose of the Establishment Clause and the Free Exercise Clause. We want to make sure that we are able to describe the limits that are on the government under the Establishment Clause, like what kind of things is the government prevented from doing? What kind of limits exist on the government because of the Free Exercise Clause? So, not only can the government not take actions that like promote a religion or anything like that, but the government can't act in ways that would limit you from doing your religion however you feel is appropriate. And then we're going to need to make sure that we can explain several of those Supreme Court cases. The big ones that we absolutely have to know by name are Engel versus Vitale and Wisconsin versus Yoder. But some of those other cases are also very important, like Oregon versus Smith and all these. Like, we want to make sure that we can explain what the limits are on the government and how those cases were decided. Okay, so that's it for freedom of religion. We've obviously got a lot to talk about. I look forward to talking to you guys live in class about all these different issues and seeing what kind of things we think about these limits. And remember, whenever we're talking about court decisions and stuff, just because the court decided things a certain way does not mean that they are always followed. So we'll have to talk about implementation of the court cases as well, especially about some of those issues around schools that you guys talked about. But so we've wrapped up freedom of religion, and now we've got to talk about the other parts of the First Amendment. So we'll spend the next couple days looking at freedom of speech, press, and assembly.